Well, thank you for joining us today. We had several other people join, but they might join a little bit later. So just to keep it timely for everybody else, though. Good afternoon and welcome to ITEN's virtual roundtable this month. Thanks for joining. And I'm going to do just a quick intro of what's going to happen today, and then I'm going to kick it off to the gentlemen. So today we have Jack James and Ernesto Segura, both from Husch Blackwell. They will be discussing today considerations for startups and leasing commercial space for their businesses. They'll walk through the major concepts startups need to focus on during lease negotiations and provide insight on best practices for startups that are going to lease commercial space. Protecting IP and proprietary information in your lease will also be touched on, and how that affects future investments and opportunities. So I will go ahead and hand it over to Jack and Ernesto.
Thanks, Connie. Hi, everybody. Thanks for joining us today. We've got a handful of folks on, as Connie said. I think some folks may jump in if you need to jump out too. We understand. Jack and I are both attorneys at Husch Blackwell, and both part of our Cortex team. We have an office in Cortex that's a satellite from our Clayton office here in St. Louis. I'm working from my satellite office at my house. Jack's in the office today, but thanks for joining us. This is a presentation that I've given before. In my years, I found that real estate can be like speaking a foreign language sometimes to folks who are better equipped to be entrepreneurs and business people, and maybe don't necessarily always feel like they've got a good handle on the real estate side of things. So we've put together a slide deck here that Jack and I are going to walk through, but we really want this to be an opportunity for you to ask questions. So as we kind of buzz through, there's a lot of information here, but we'll try and go through it in enough time that we'll leave some time at the end. But as we go, please do not hesitate to unmute yourself and jump in with a question or ask a question in the chat. We'll keep tabs on that. But both Jack and I work in the real estate group. And we represent a wide variety of parties to the transaction, whether it's landlords, tenants, businesses, brokers I've represented before, public bodies as well. So we've got a wide variety of experience in handling all different aspects of this, both from mature companies, startups, et cetera. So we'll go through the slides here. Jack will run through them, and then I'll weigh in as well. But like I said, please absolutely feel free to jump in with questions as we go here. We'll do what we can to try and get you some good information. All right, Jack, take it away.
Perfect. All right, first things first, just a brief overview. So we'll talk about general considerations in commercial leasing, options for space, and then key issues. So first off, general considerations, location, and this can vary on the type of business that you have, especially for startups. Retail businesses, location is going to be key, mainly for customers and your employees. So this can kind of determine where you want to look, if it's high traffic, if you're thinking retail like grocery store, or if you're a specialty business like a bridal shop, maybe that's not your main focus because customers will go to you anyway. And then for service businesses, location may be less important, but you still have to think about your employees, maybe public transportation. If that's something that's important to them, that could play a role as well. And then Ernesto, if you have anything you'd like to chime in.
Well, I would say too, the other consideration obviously in location is if you are entering an industry where you want to be around other folks in the same industry, that's certainly a consideration. But it's no secret that a key first step in real estate is location, 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 regardless of what kind of business you're running.
Right. So next we have minimized costs. This one's important. Unless you're a real estate developer, real estate is overhead. Maximizing flexibility. Real estate needs to grow or contract in response to business growth and evolution. Think not just now, but maybe 3 years from now. Will your business need more space? Lack of leverage is important for startups. Financial and business history is essential in negotiation. If you're a new business, that may decrease your leverage unless you've shown great financial strength so far. And then timing, when do you need to get into your space? When do you need to use it? And how long do you need to use it?
Yeah, we'll go into more detail on all of this, but I do think that the more you can do to actually put a real estate component into your business plans, that is an essential thought. You may not need business space when you're first starting, right? If you're just working from home, trying to get something off the ground and you're not scaling to have employees yet, or if you have a couple of employees, but you know that in the next 5 years, you're looking to scale up to significantly more, all of that, you're planning from an employment perspective, from a business perspective, you need to have layers of real estate put in there too, to give that some thought.
Definitely. Next, so we have types of property: office, executive suite, innovation community space. Think Cortex is perfect for small startup companies that need office space. You have traditional office space, and then it varies out a little bit: industrial, warehouse, ground, retail.
I would say another consideration, and it sort of ties in with this executive suite space. You're looking at smaller spaces, relatively low costs of entry, and they allow you to have some short-term options. It's not always just shared spaces like WeWork or any iteration of the shared space. You can think about taking space in a different office. My wife is a small business owner and is negotiating. She's in the healthcare space. There's a health clinic that has offices that she thinks would partner well with her practice. So she might lease a room from them, right? There are different ways to do this. It doesn't have to be a traditional, that's my building, that's my suite number. There are, the executive suite space is one of many iterations of this flexibility model that gives smaller businesses, startups, or early life cycle businesses some real flexibility and opportunities.
Yep. And to continue on this, I know we've had the slide up for a second, and a lot of them come fully furnished, so that helps minimize costs as well. One thing that may be tricky is that you might not be able to bring in your own furniture, you may not be able to make renovations, but it does offer extreme flexibility, shorter terms that can really help startups as they get started. To the next one. And then to follow up on that, we have the innovation community space. So this is the one I said, think Cortex, focus on startup communities, flexible pricing, could even be by person, and then various amenities, kitchens, internet, 24/7 access, security. This also has high flexibility generally, shorter term leases. Financial business history is not as much of an impediment as it may be elsewhere. And then now this is important as well. Security issues are high for startups, and sometimes this may not be adequately addressed in campus communities. But
yeah, we found that to be a sticking point on some of the shared space, is the idea that, you're working on something that you think is innovative, and you've got somebody literally right next to you working on something they think is innovative, and you may not want them seeing what your innovation is compared to theirs. So, sometimes the flexibility, the shared space concept, being around people is great for brainstorming, collaboration, different things like that. But the minute you start to try and pick a lane and really focus on your IP and your work product, there tends to be security issues about how do I protect that IP? How do I make sure that somebody's not taking my ideas without my consent? So as with all of this, as we'll go through here, there's going to be pros and cons to every type of model. And that's why it's important to think all this stuff through.
Right. So commercial leasing, negotiate. This is an interesting one because most times, especially for startups, you'll get the first version of the lease you'll get is from the landlord. It'll be very landlord friendly, and often it'll probably be even a PDF. You won't even know you have the chance to revise it or negotiate it. But it's important that you do, because everything that's in the lease document will be what governs the agreement. If it's not in the lease, it will not help you.
And it could hurt you, right? I mean, this is, it says it there, Jack, it's not your college lease. This is not where it's a take it or leave it. You are now running a business. You got to think about what you care most about, right? Maybe furnishing is not as important to you as making sure you have 4 walls that aren't going to let people hear your phone calls or your video meetings. The rent obviously is something that can be negotiated. Term, everything is a negotiation when it comes to real estate and these leases. Do you want options to grow your business? Do you want options to be able to give space back at a certain point in the lease? All of it's negotiable, but you got to start thinking about it from the front end, because as Jack said, if you don't have it written, it's going to be hard to go change what the wording of the language is without giving something up. Landlords want you there long term, and they want stability. They don't necessarily want to be talking to you every 6 months about your new needs. So the more you can do to plan ahead and build in that flexibility into your lease document, the better.
So next we have the letter of intent. So a letter of intent is a document that includes the important terms, think base rent, term, pretty much governing the lease agreement or the topics of it. And an interesting thing here is letters of intent are generally not binding. They will say that in the agreement, they'll be signed, they'll say it's not binding, but the effect that they have is almost binding because people try to stay very closely to what's in the letter of intent. And if you veer away from that, the other party they'll tell you, well, what happened to the letter of intent? You agreed upon this earlier. So it's important to take the time to negotiate this, to really be thoughtful about what you want included, what you don't want included, because that'll govern negotiations generally the rest of the time.
And here's the dirty little secret. Landlords have form LOIs and they have form leases, and they take their LOIs and they change the 5 provisions in the form lease to match whatever they put in an LOI. So, they're looking to do the least amount of work to get you into their standard model. So if you're not negotiating, it's less work for them, more stability for them. The more that you focus on the things that are important to you, like I said, everybody's needs are different. Everybody's wants are different from a tenant perspective. The more that you can do that on the front end, get it into the LOI, then when they go to the form, you can work with it however you want. But everybody has sort of said our intent is that this is going to be the agreement, which is why these sometimes are an overlooked part of the process, but are a very important part of the process.
Okay. Next, we have security deposits. So for startups, it is very likely that the landlord will require a security deposit. So generally, we say be prepared for some amount, 1 to 2 months base rent. Sometimes it's possible to negotiate burn downs of security deposit if over time there have been no defaults, you've been a great tenant, that you can get some of that amount back. And then determination of credit worthiness is not necessarily based on earnings or profits.
Yeah. So now we're starting to get into some of the foreign language stuff a little bit here, right? But these are the type of examples of financial terms that you're going to put into an LOI and then see in a lease, right? So the security deposit, obviously, just like a residential lease, it's securing the fact that you're going to perform, and then they've got that there if they need it, if there are damages because the space is damaged or you don't pay them rent, etc. But you hear us talking about base rent, right? So typically base rent is the minimum amount of rent that's due every month. There's usually then additional rent, which is some portion of a shared operating expense for the building. So if you're one of 10 tenants, they're going to take the costs at the landlord's costs and spread those out amongst the 10 on a proportionate basis, right? So then you got a base rent, you've got an additional rent. Sometimes if there's a retail component, they'll try to put in a percentage rent where they will take some of your earnings or profits. So there's all sorts of iterations and variations on that. But the struggle you have as a startup is you don't have the track record financially that's going to make these landlords think you're able to pay the rent for the entire term of the lease, right? You're a risk to them to a certain extent, right? It's a different story when I'm leasing space and Edward Jones comes in and says, we want to rent space, they're probably not going to be putting on a guarantee on a 10-year lease because they know Edward Jones is going to pay their bills, right? But if it's some startup, they don't know that. They don't know your business record. And so what they're going to do is say, yeah, it might be your business that's signing the lease, but it's going to be you who go on the hook personally, right? So I have a client right now who's a tenant. That she and her husband are chiropractors. They have a small chiropractic practice. We're negotiating with the landlord. They've been tenants for 7 years and they're working on a long-term renewal, but the landlord still says, I can't take the risk that your business isn't going to go under. And I want the two of you personally responsible as a guarantee. You're going to guarantee the financial performance under the lease, right? Because one key thing to remember, security. The landlord wants this to be secure. And so the promise is if you sign a 10-year lease, if you sign a 5-year lease, you are locked in legally for those 5 years or 10 years, unless you negotiate otherwise. So if you say, I'm going to sign a 10-year lease because it gets me lower rent, and then 2 years in, you realize you got to change, the business isn't working the way it wants, you got to fold up and move elsewhere. Sorry, you're still legally responsible for the full 10 years of rent to that landlord. And if you want out of that lease, that landlord is going to say, great, then you're paying me 10 years worth of rent now to get out, or they'll negotiate something along those lines. So the money part is important up front, especially on the guarantee front, because that's where they can get at you personally, even if you have an LLC, a corporation, some sort of entity that you're using for the business. If you sign a personal guarantee on a lease, they can get past the entity and come straight after you and your money.
So next we have permitted use. So this one's key. You want to keep it as broad as possible, especially in the business of startups, because what your business is doing now may not be exactly the same as it is 2 years from now. Say the lease permits you to do one thing, provide one service, and 2 years from now, you want to add something. You don't want to have to go back to your landlord and have to amend the lease. So ideally, you'll end up incorporating something along the lines of any and all permitted uses are allowed in the lease premises during the term of the lease. Sometimes you may not get there, so you still want to be as broad as possible. Some listed here, some unique uses that need upfront permission: cafe, pets, overnight parking. So you want to incorporate all of these in there if you can. If you can't, just get the any and all legally permitted uses.
Yeah, nobody's going to give you all permitted uses permitted by law. You best is if you're doing office space, they'll give you general office uses, right? You can always try and broaden that and say in other ancillary uses, that wouldn't require a change in zoning or something along those lines. Basically, you want the right to have some flexibility in what you're doing. Landlords, on the other hand, want you narrowly tailored so that they know what lane you're staying in, right? And it's one thing if you're going to be doing a business, but as Jack notes, and as we say here on the slide, there are all sorts of bells and whistles that you may have in how you want to run your business. And you're going to want to think through that up front, right? Whether it's pets is a big one, right? Hey, we've got 5 employees. We want them to be able to bring their dogs in. It's not up to you. It's up to the landlord. And if the landlord says no, and it's in the lease, no pets allowed, you're not going to get the chance to bring the pets to work without defaulting on your lease. So that's a big one. Sort of employee amenities that sometimes might be a little out of the ordinary have to be addressed in the lease. A big one here is equipment or utility needs, especially if you're in particular industries that require special needs. If you're sort of in an IT type setting, you've got high server usage, or you need extra electricity or extra cooling in a particular area. That's something that we often see. If you're in the biotech area, you might need there might be certain waste products that have to be addressed, right? Think about from a retail perspective, it's a food service type space. They have to have grease trap options. There's all sorts of those things that are specific to the business, where the landlord's going to want you zeroed in on all of it. You're going to want to try and be as broad to give you the flexibility, but you're going to see a lot of movement in an LOI and a lease around permitted uses.
So continuing on along this line, so some examples of uses that will require the consent of the landlord, and they may be concerned about, are any use that may produce waste, hazardous waste, because that can create environmental liability long-term. Something that's not listed here, or say that the property, the lease premises are subject to a declaration or an association. They're in an area where an association, the governing body, gets to approve or disapprove certain uses. So that's something you're going to want to talk to the landlord about, because your plans for the premises may not actually be something that's generally approved by an association, which is not even a party to the lease agreement.
Yeah, and the association example would be like if you're in office space on a first floor of a condo building, right, where there's residential condos, but then there's commercial condos on the first floor, and you're taking space there. Typically, all of those condo units have an association that have to govern all of that. There's layers of approvals here that you got to think through on the front end. So security and data issue spotlight. So intellectual property and proprietary information is arguably a lot of startups' number one asset. So this is something that you should ask for security related requests in your lease to protect this information. And this can come in all types of forms: visitor security badges, advance notice before entry, 24 hours, 48 hours for your landlord, require landlord representatives to be escorted by somebody from your company, your business, negotiate NDAs before third parties can enter. And then the last one, consider designating off-limit areas, and that even applies to landlord if you can get them to agree to it in the lease, just depending on how sensitive the information you are working on is. Yeah, and landlords are generally amenable and understanding of this need. Their concern is going to be, and you'll hear it if you're talking to a landlord about it, their concern is going to be about access in the case of emergencies. It's the building's flooding and we got to get somebody in there to do something, and it's 2 o'clock in the morning on a Saturday night. I can't sit there and the pipe is leaking in your wall. I can't wait for you to come let me in because you're worried about my plumber seeing your biotech startup technology. So that's where they're going to be coming from, sort of the practical standpoint. But finding landlords that have a robust security system built into the building is often a good first step in asking those questions about, well, what do? Do you have electronic access that we can sort of piggyback on and make sure that we've got that? Is there a, sort of entrance point where everybody's got to go to a front desk in the building as opposed to just walking into the individual suites? All that sort of stuff you can think through on the front end. But if you have specific areas, if you want some advance notice outside of emergencies, landlords are usually pretty reasonable about understanding that. So ask for it.
So Ernesto touched on this a little bit ago, but base rent. So rent, what it is and what it's defined as in the lease can be different between each lease. Is it a gross deal to where you're paying one price for everything? Or is it net where you're paying base rent, but then you also have to factor in insurance, taxes, and maintenance separately from that amount? So controlling additional rent is possible with certain mechanisms: audit rights, fixing costs, capping increases. So example would be, for some leases, the landlord may say, I'm going to give you an estimate of how much real estate tax will be at the beginning of the year. You're going to pay that each month. You're going to break it down, divide it by 12. But then you'll say at the end of the lease or at the end of the term or year, we would like to audit and see how much they actually were. So that way, if we overpaid you, then we get that back. If we underpaid you, then we'll pay you the difference. So that's key. And then Ernesto, if you have anything you'd like to.
Well, yeah, I mean, it's, as you can imagine, there's 100 different variations on how that works, right? Sometimes you say, oh, if we're within 5%, either way, you're not going to credit us, and we're not going to pay you more. We'll just say it's fine. Oftentimes if you're a small tenant, landlords aren't going to give you audit rights. They're going to say, no, you're just going to pay what we tell you to pay, and we'll true it up at the end of each year. But you might have the opportunity to say, okay, but I want some limits on what the year over year growth is, right? You can't be adding expenses for new categories that you weren't giving at the beginning of the year, right? Like, I don't want there suddenly to be, it's a small building, but suddenly you decide that you're going to have valet parking, and you're going to charge me all this more money for valet parking when I don't have people coming and parking at the building. So you weren't given valet parking and charging me for it at the beginning of the lease. You can't suddenly 2 years in decide you're going to, or you can't increase my additional rent more than 5% per year, right? So you can't have 20% increases year over year. You're capped at 5. Different things like that. Making sure that if they're going to pass through, this is a big one, if they're going to pass through capital expenses, they're putting on a new roof on the building, but it's the last year of your lease. You should only have to pay your proportionate share of that new improvement, that capital improvement, amortized over the useful life of the improvement, right? So if the roof's designed to last for 30 years and it cost $90,000, well, then you should take that $90,000 and spread it over 30 years, and then take that first year's amount and divide that up amongst your tenants, because I only got the benefit for that one out of the 30 years. So I should be paying a reduced amount. You can't just dump the whole 90,000 on us the first year. Thinking through those provisions in a lease and talking either to a broker, right? We've mentioned brokers here who often can help with this sort of stuff, or to an attorney can be really helpful, because they know the sort of ebb and flow of the negotiations around those points.
Next up, we have alterations and restoration. So here, a key item is the startup tenant should reserve the right, but not the obligation, to remove any alterations containing intellectual or proprietary property, such as signage or specialized alterations. So here, let's see. So it's limited landlord approval rights. So generally you can see this in structural alterations. So if it's not structural, it's not going to impact the building long-term. It can be easily removed. You don't want the landlord to be able to veto that right off the bat. And generally they're amenable to this in certain situations. And then the next one is understand the timing of the approval process. So you may have everybody ready to go. You may have contractors build improvements, but if the lease says you need to give the landlord 60-day notice and they have approval rights on the final design of the improvements, that can set you back a little bit. And then in regard to the restoration, landlords want to re-let the space the same way you took it. It's important to negotiate with the landlord to advise on how they want the removal process to go, when the removal needs to take place. If it needs to be 30 days before the expiration of the lease term, 60 days, you want to know that long before that date comes.
Yeah, and a good example, right? And I'll use an analogy here. So in the restaurant business, you sometimes get these big walk-in freezers that get installed in restaurant spaces. Then the restaurant goes under, and then there's a fight over who owns the walk-in freezer, because is it so big that it's immovable that it becomes, essentially part of the real estate, and the landlord's trying to claim it. Why? Because they got to find another restaurant to go in that space. And if there's already a walk-in freezer, that's easier for them to re-rent it to somebody new, right? But the guy who just shut down the restaurant, he and his wife may want to take the freezer and pay to get it moved somewhere else, because they're actually not closing their business. They're just moving down the road, right? And so you got to think about that. And the extension, obviously, and and I've seen this actually in a lease, 3D printer was at issue because they moved in, they didn't have much by way of furniture or anything of that stuff, but they had a giant 3D printer that they were moving in, and they didn't address it in the lease. And then the tenant was asking for help because they outgrew the space and they wanted to move. And the landlord's like, well, you're not taking that with you, right? Because you didn't say that you get to take all of your equipment and stuff with you. And so if it's not in there to say, hey, if I put something in, I get to take it out, right? If I've got this cool sign that I get commissioned to put up in the window, I want to take that with me. That doesn't just get to stay with you. If I got to buy all this expensive equipment and invest all of this money into an equipment for some sort of thing that I've got to move in, even if it means you have to pay to knock down a wall to get it out, it might be something you want to pay to knock down a wall to get out, to take with you. So again, that's why I said at the beginning, the whole planning of what your life cycle is and what you want to bring into the space, what you want to bring out of the space, and who's responsible for what and how that's all going to work is stuff you got to think about on the front end.
Okay. Assignment and subletting. So this one is important. You want to have as broad of rights as you can here. So assignment is assigning the lease to somebody else. They're going to take over the obligations. They'll take over the space. And then subletting is you're still primarily on the hook, and it could happen as assignment as well. But another tenant will come in underneath you. So you want it to be as broad as possible. Most landlords, especially with startups, will not agree to that because they'll say they vetted you. They haven't vetted whoever you want to bring in. So normally you'll have to require prior consent, and which is completely fine. Or you can also veer out and say, but not to an affiliate. So it's another company that's related to you, can assign without consent. That makes the process easier for you and the assignee who you want to bring in.
Yeah, I would say too, the other thing you got to think about here goes back to the security, right? The financial security. They're making a deal with you. I don't care about the business as much as they care. You're probably on the hook for a personal guarantee. So you got to think about this because a key part of a life cycle is equity investment, right? And if you're getting an influx of equity and you're giving up control of shares of your business, you start to have issues with this assignment and subletting, right? Because is your giving a majority of shares to a new entity and that change in control, is that in the lease defined as an assignment for which you need the landlord's consent? You don't want to have to go ask your building landlord to consent to you getting a 51% equity investment from some entity, right? But if you don't have it in the lease, you're going to have to go get consent because that was defined as an assignment because it was a change in control of the tenant. Why? Because the landlord's making the deal with you, right? And if you do have provisions that allow you this flexibility to go and transfer it to an affiliate or to reorganize or to bring in an equity investor who's going to own more of the shares, but you're going to be still running the day-to-day, you got to think through whether or not you have plans to do that during the term of the lease, build it in, and then also think about the fact, going back to the burn off provisions of a security deposit or of the guarantee, right? If it's a 10-year lease, maybe you say you only are on the hook for the first 5 years. Then you've got enough of a track record. You can have that guarantee burn off, right? Or if you do need to negotiate with the landlord because you're going to change the structure of your business, is that an opportunity for you to say, you got to let me off the hook from the personal guarantee? If you're selling, if you're bringing in a majority owner that's not you got to think about the fact that you may still be on the hook with that personal guarantee. So it becomes really important. And Jack moved to the slide that talk about these exemptions, right? What are the carve outs that give you the ability to run your business and grow your business without always having to go back to your landlord? And these are examples where if you can get a full carve out, great. At a minimum, you want to make sure that the landlord consent cannot be unreasonably withheld, conditioned, or delayed, right? Those are the magic 3 words. You never want it to be unreasonably withheld, conditioned, or delayed, because then you at least have some hook legally. If you ever have to go to court because the landlord's holding up this deal that's going to change your business, you can go to court and tell a judge, listen, they're being unreasonable here. They're actually a more financially solvent company than us, right? And they're not letting me off the hook. But you got to have it on paper, because a court is not going to look at everything around the lease and all the sort of ancillary stuff. They're going to look at the document. And if it's not in the document, they're going to say you're out of luck. It's in our world, we call it the 4 corners of the document, right? If it's not on paper, you're kind of SOL. So just more reasons to actually put these carve outs in, and at least put some conditions on the landlord being reasonable and not holding up you being able to do your business as it grows.
So then preferential rights. So one of the big one here, especially with startups, is renewal options. And we have here 95% of market value. And that's because if you're going to renew, and the landlord accepts it, you're saving the landlord money in terms of how long they'd have to wait with the space being vacant. They'd have to hire a broker to find a new tenant potentially. So you're going to look to have 90%, 95% of the market value. Your rent may still go up, but it won't be as much as it normally would be. And then early termination option with startups, especially how risky some businesses can be, you'd like to have an exit strategy if possible, especially if the business doesn't work out the way you'd like it to. Expansion, also big with startups. So say 5 years from now, from the date of your lease, it's 10-year lease, your business is growing exponentially, you're hiring a lot more people, there's a space in the same building, and you have the option, your current lease, to expand. You just have to exercise the option, and then rent will adjust accordingly and all of that. But these are all key provisions to have in your lease for startups that could come up relatively quickly.
I would say too, the last one there, rights of first offer and the right of first refusal, those are important. They kind of get confusing sometimes for folks who don't speak the language of leases. So a right of first offer is if there's space that's going to become available. Typically, it has to be contiguous with the space you're currently in. A right of first offer requires the landlord to tell you, hey, the suite next to you is coming open. You have a right of first offer. You can offer me something to rent it. And then if we agree, great. If it's not agreeable, then I can go market it, right? A right of first refusal is where they may have a tenant who's already signed a letter of intent, so they know what the terms are. And then you get the chance to sort of refuse to let them lease it to the other person if you match those business terms. So again, these preferential rights is you got to come talk to me, or you got to give me an out. And it all goes back to the theme that I keep hammering home here, which is to the extent that you can include your real estate as part of your business planning, your long-term business planning, you're going to be better off because you're able to start thinking about this stuff, to be able to say, okay, I'm going to go into space and maybe it's only, 1,000 square feet to start, but I have plans in my business plans that in a few years, I'm going to need 2,000 square feet because I'm going to double in size. Well, then you may want to talk to the landlord about putting in a right of first offer on the space next to you, if that ever comes available. You might also put, if permitted uses, right, we talked about earlier, if that's one of those things that you're particularly concerned about is having a competitor in the same space, you can get some preferential rights around exclusive uses to make sure that, you're not having a competitor who's doing the same thing come into your building, right? So I use the example of Edward Jones leasing space and not having to sign a corporate guarantee because they're such a massive financial institution. But at the same point, oftentimes they have the leverage to get a landlord to agree that they're not going to have other brokerage companies in the same building, so that they get an exclusive where it's only Edward Jones financial advisors in that building, and you don't have Wells Fargo or Stifel or other people who are doing the same line of business in that space. It's harder to get when you're a startup and don't have the same leverage that a big corporation like that may have. But if it's a unique business, it may be something that the landlord's willing to agree to because they don't expect that they're going to have another, company come in with that exact use. And if that gets you in the building, they may be willing to do that. So it's always worth considering doing something like that for the preferential rights too.
So in relation to flexibility, early termination, extension rights. So we just touched on it, but to ensure as much flexibility as possible, always seek renewal options. And this goes back to assignment as well. Try to ensure that the renewal option is assignable to an affiliate or permitted transferee. And then with regard to termination rights, if a landlord, if say you rent a space and you grow quickly, but the landlord can't keep up with it and you don't expect to early on before you sign the lease, try to negotiate in a termination right. And generally you'll have to pay something for it, but at the same time, that's a reasonable trade for being locked into a lease that is too small for what you need.
Yeah, and you got to think through the term as well, right? Landlords want longer terms for that stability, like we talked about. You may want a shorter term with multiple renewal options, right? So you thread the needle there and say, well, I'm not going to sign a 10-year lease, but I'll sign a 5-year lease, but have 2 renewal options. So maybe you get me for 15 years, right? That's the sort of negotiating and flexibility that we're suggesting you take on the front end.
And we just have some special considerations for some lease. So industrial warehouse, fencing, security, truck access parking, loading docks, and then retail exclusive use, kind of like Ernesto touched on. If you're a clothing retailer, you ideally would not have a clothing retailer right down the street from you at the same building. And then reciprocal easement agreements, you and the party next to you have to cross over each other's parking lot, something like that. Outdoor seating, drive-through, which often involves conditional use permits just due to the higher traffic.
Yeah, those are tricky ones if you're in sort of a retail center, right? These reciprocal easement agreements are very complicated documents that don't make a lot of sense when you read them, but it may impact where you park, right? If you have exclusive parking, or if the people who are coming to your store can only park here because the spaces over here are for the person down the road. You know, those are often outlined and controlled by these complicated reciprocal easement agreements. Outdoor seating, you may assume, oh, well, there's a lot of space. There's people who have outdoor seating already. You better put it in the lease and negotiate it ahead of time, because oftentimes there are limitations not only from the municipality on what you can be doing and what hours you can have outdoor seating and where it can go, but there are also limitations that the landlord may have in these types of reciprocal easement agreements, saying here's how close you can get to the curb. You can put up a little fence, or you can't, to clarify it. Maybe you have shared outdoor seating. There's a lot of nuance to how these sorts of things work. So always important to think that through if it's something that matters to you.
All right. And then questions,
Okay.
if anybody has any.
We buzzed through a lot of stuff. If there's anything you want us to go back and touch on with a little more detail, we're happy to do that as well.
Rick, any questions? I just had a really quick one for you guys. I know when you talked about the, when you're leasing a space and say they do it, like you say, a big improvement. Now that's probably something that you wouldn't know when you lease the space, if they're gonna do a big improvement. Is there like, you know, are you stuck with that as far as like paying for something like a large, I know you said, you know, you can only, you know, you spread it out for the time that you have left there or whatever, but what if they have like, I don't know, a disaster, they do something and they have to redo everything, you know, are you stuck with that?
That's a good question, Connie, because the example I gave of the chiropractic clinic that I'm representing, they reached out to me because their space burned down. There was an electrical fire that started in the empty space next to them and completely destroyed their offices. So, you know, they had just done the lease themselves with the landlord, and the landlord, the provision said basically, if we can't figure out how to rebuild it in 6 months, then the lease automatically terminates. Well, they called me a year after the fire because they were still trying to figure it out. And I'm like, I looked at the lease and I said, well, you technically don't have a lease here, right? So a lot of this stuff is difficult to anticipate. If it's a casualty, right, which is what we would call a fire or something, those you can't really predict. But what you can do on the front end is ask questions of the landlord, right? Or their broker, right? When was the last time, when did they replace the roof last? When did they upgrade the HVAC system, right? These big systems that we have, HVAC, plumbing, water, utilities, you know, when was the last time they upgraded any of that? That'll give you a general sense of whether something's coming down the road, right? If they haven't touched any of these systems in 20 years and you're signing up for a relatively long-term lease, you may expect that there's going to be something there. And then you can go about negotiating on the front end to say, okay, that's great. But if you're going to have to replace all of the HVAC units, then I don't want you dumping all of that cost on me. So you can ask those questions. I think that's the best way to protect yourself is get informed on it as best you can from the landlord or their broker.
Right. Good advice.
I had a quick question.
Hi.
I did have to step away for a second to take a call, so I don't know if you went into this or not.
No
But
problem.
what kind of, if you're entering into a situation where the landlord may have to, come in to do these repairs, and that is disruptive to your business, and what kind of language should, when you're negotiating up front, like, what's appropriate to ask for as far as notifying and what the definition is of comparable space, if they're trying to like, oh, well, we can move you here while we take care of this hole in your, wall or whatever.
Right.
That kind of stuff.
Yeah, there are a couple of different ways you can approach it. One, you can ask the landlord to do all the work outside of your office hours, right? So you get somebody in there in the evenings and on weekends to do it so that you're not disturbing my space. That's if it's something that can be done that's not going to have everything covered in dust and dirt, right? If they need to move you to a comparable space, number one, make sure you do an actual lease amendment that actually determines what you're doing. Focus on what you're going to get, right? And you can have that in your original lease, right? You can have relocation space or temporary space built in that says, hey, if for whatever reason you need to move me, it has to be on the first floor, right? Or the same floor that I'm on. It has to have access to the lobby. If there are particular points that you need, put it in the lease, right? And say, hey, I'm fine if you need to move me because you're going to replace all the windows, right? All the exterior windows. And so it's going to be open air. I can't be working in open air, but you got to move me to a comparable place. And here's what we define as comparable, right? And you're going to pay, if I have to move furniture, you're paying for my moving, right? Sometimes landlords want to put in a relocation right where they want to be able to move you permanently because they got a bigger tenant or somebody that they need that space for. If they're doing something like that, make them pay for new stationery and business cards because they're making you change your suite number and stuff.
People use stationery and business cards still?
Yeah, they do. And you'd be surprised how often it's a big deal, especially for like bigger tenants, where you're taking up multiple floors and you've got thousands and thousands of people's business cards that you need to change. That becomes a big ticket item.
What CIC did to CET, changed the address because they changed the front door. And and everybody
now what are you going to do? Right.
Everybody had to get new stuff.
Right. And I mean, it's not hard to think about that and to put it to say, hey, listen, if you ever change the address of the building, you're going to cover any reasonable cost for me to change my web page, right? If you're using a web designer, you got to go on your web page and change all your address stuff. Maybe that costs you a couple of $100, have them pay for it. Right. But for the temporary space, defining what you want to be comparable, what matters to you. It's the same square footage or bigger. We're going to agree to it for no more than 6 months, something along the 3 months. You got to think about what the pressure points are for you. Maybe it's somebody that you need to make sure that your customers know where to find you in the building. So they're going to put a new sign in the lobby that says, hey, Melissa's temporarily moved over here. Here's how you write, like something like that. It's a matter of what's specific to you. But if that doesn't get in the lease on the front end, then when they approach you about it, that's what you got to put it in the amendment and get it in writing as best you can.
And I think too, one thing with startups, well, sometimes they're moving so fast and making additions and changes that sometimes, just being reminded to stop and go, okay, we did this leasehold improvement, or, for example, I had an experience where we put in airlines that had to go into compressed air, had to come into the lab, and then they needed to move us down the hall that didn't have compressed air and didn't have things, and it made us not be able to meet grant deliverables because we couldn't do the science kind of thing. And that was like, we had everything in the lease that was like, this is ours and this is yours and this is stuff, but as we made changes, like at living in the space, those cleanup things, I think sometimes don't get, it's one thing to move somebody that's more of a service industry. It's another thing to move a wet lab.
No, I completely agree. And it's sort of hard to predict exactly when that situation might arise. And so, but that's why I think as those situations pop up, you gotta, it's usually moving for a reason, right? Like like you said, if there's a hole in the wall and they got to move you to a new space, you're moving so quickly that it's sometimes hard to take a moment, think about it, and actually think comprehensively about what's going on here and set some boundaries, and try to get that in writing with the landlord so that everybody continues to know how they're going to behave with each other.
Point of information, core drilling is very loud, and they will make you do it when you have to pay people time and a half to double time, because it will disrupt other people's ability to do their work.
Yeah, and
space.
that was another part that we didn't really touch on, but business interruption, right? So sometimes you can build that in, and usually it's in the case of like, oh, the power goes out, right? And tenants will say, well, if the power's out and I can't use my space for more than 2 days, you got to start abating my rent so that I'm not paying you rent for the days that I can't be in the space. It's a little harder now in the more hybrid work life that we're living in, but landlords typically push it back and say, well, no, it's got to be more than like a week, so like 5 business days, and we have to have some control over it. But those are all things that are negotiable, right? Where you say, listen, I've got a lab, I have specimens that have to be air conditioned or kept at a certain temperature, and if the power's out and we've got backup generators built in, but they're only going to last me 2 days, like
and where's the liability if that stuff dies?
Exactly. We need to know that, but that's where you got to think ahead of time about all of those worst case scenarios, because I guarantee you the chiropractors I'm helping, they didn't think their place was going to burn down, right? And now it did, and now they're scrambling, and it's a year and a half later, and the landlord's dragging their feet building it out, and they're like, what are we going to do here? And because nobody wants to think in the worst case scenario except us weird lawyers. So
well, we're now all reading the pandemic small print more than we used to in those in those
everybody knows force majeure now. Yeah, that's for sure. Thank you for the question, Melissa.
Anybody else question? I guess not. Well, we thank you again, Ernesto and Jack, for this great presentation. There again, like Melissa mentioned, the startups are so busy doing their thing that I think that they probably don't think about a lot of those things. So I think this is a very well, presented, a lot of great topic. And next month we have another topic from Husch Blackwell on the fun stuff, employee benefits for startups. So that'll be the third in the series, and you can catch all of these, this great wealth of free information on our YouTube channels. And we'll share it with you guys all as well. And they may have, PowerPoint slides that you can also get. So we'll follow up with you all after, after the presentation. So
yeah, we can certainly provide them to you, Connie, and you feel free to share them with whoever would like them.
That's great. That's great. Thanks so much, guys.
Thank you all. Take
Thanks
care.
for being here and making us pay attention to the things that are not always the fun things to do.
Absolutely.
You come through it, and then they come
yes
at the top the next
then
time.
You really care about them. That's right.
So thank you for those good reminders.
Thank you all. Everybody stay cool out there.
Yeah.
Thanks, everybody.
Have a good evening.
All right.
Bye-bye.
Take care.
Bye.